Welcome back to ITLS Academy. Myself, Advocate Priyanka, and today we are going to talk about the copyright topics as in continuation of our previous session. So, today's topic will be about the international copyright law. So, see what's in your today's plate in this session. So, for this session, we have added some contents highlights of previous session. As you know that it is mandatory. And then second is what is this is today's topic, that is what is international copyright law. And third, we will know that why we need international copyright law. Why only domestic copyright law is not sufficient. And at last, we will see different international treaties that provide copyright protection at the global level. So let's start. So highlights of previous session. So in our previous session, we have talked about the copyright search. So basically, we talked about that why we need copyright search. So we need copyright search to check that our creation is new or not. That means our creation is novel or not, or is our idea is just confusing similar to others, like someone other has the same idea and I have the same idea, and it can be same idea in copyright, but is my way of writing or is my way of presenting is similar to the others. So we have to check that also. And then at last, by the copyright search, we can also check that not only we or not only me, even if others are stealing my idea or others are stealing your idea, you can also search for that in the copyright search. And this search can be done on the web page copyright.gov.in. It is not on the regular ipindia.gov.in. For copyright, there is the separate web page. And then next we talked about that okay, we did the copyright search and we found that our creation is new. So what will be the next step? What will you want to do in next step? Obviously, me or you, we will want ownership for that particular creation, and we will we want that no others should steal our creation, no others should infringe our creation. So for all this, we need to do the copyright registration. So in our last session, we discussed about copyright registration process in India. So today I'm not going in detail for that, this for the same thing. So I have just given highlights that what we discussed in the previous session. So let's start today's topic, that is international copyright law. So basically, see, if any work is created, then it is not like that if you have registered or you got protection in your own country, it is protected globally. It is not protected globally. And for that, we need international copyright protection. So your work remain protected globally all over the world. And for that, there is international copyright law. So we will see that what is the basically international copyright law. So international copyright law is the basically collection of different type of treaties and agreements. And the main aim of these treaties and agreement is to ensure that there must be mutual protection for copyright across the border. Like if one country is giving protection to others country, then other countries should also give protection to that previous country or that the origin country. So it it should be mutual, it should be not one sided, and for that we have different type of international treaties and agreements which ensures this type of protection. So this is the basically, in short, we can say international copyright law. Now of course, as I told that we will see that why we need international copyright law. So see, earlier, before to this digital age, digital age is from since so many years, but you can say that now everyone has access of internet, everyone can use the internet. So now it is the completely digital era. So before to this digital era, there was no need of this type of international basically international copyright law. So if, for example, if someone wrote some book in particular country, then it was very difficult to go that book in, I mean, to copy that book from the other countries, because that time it was not, digital was not frequently, internet was not frequently used, so it was very difficult. But now, what is the period? Now it is a completely digital period, and here, if you create something, you just leave the book. If you create some small reels or something, you create here, and it will be go globally, like different type of platforms, that is Facebook, social platforms, Facebook, Instagram, or you can say LinkedIn. Everywhere, from everywhere, your work can be published online and anyone can use your work. So that is the main thing that we need, international copyright. So here I have written some points basically. So why we need basically international copyright? Obviously, to publish your work online. Like if you are publishing your work online, then how you will ensure that is it safe or not? Anyone can come and copy your work. Second, using content online. Like you have some content, you have made some content or something else, and you are using it through the online. In that case, also you need the international copyright law. Now, access of your database by your employee or trusted friends while traveling out of the country. So some of your employees are working with you here, and they have some copyrighted database, or they have some important database, and they are traveling to another country. And if there they just misuse your database, then you can't do anything, because in that country your database is not copyright protected, and for that your employee or your trusted friend can give any excuse. So for this, it is also essential international copyright law. And then another is share of research papers. Like in nowadays, from the different countries, from the different places, two researchers can work jointly. Like someone is doing some work here and someone is doing some work in Germany, and they both are collaborating. So obviously it is the work from the different countries, and in this case it should be protected in both countries. Otherwise, your colleague from the Germany can misuse your work, or if you want, you can misuse their work, because that work is particularly copyrighted in that particular country. But if it is protected in both countries, then that protection is more strong and no one can misuse others' work. Now, access of photos posted on social media by persons from different country. Like as I told, now there are so many social platforms like Facebook and other things. So they are just we are just posting our photos. So if we have some important photo or some important thing what we posted on that social media, so anybody from other country, from different country, can come and use that photos, or you can say misuse that work, or misuse that photos, misuse that content. So for that we also need the international copyright law. Now, teaching online students located in various countries, like see, we have now teaching, it's not like just like offline or in the classroom. Now teaching is also gone through the widely in the, you can say in widely we have gone through the online teaching. So for that purpose also we need the international copyright law. So it should be protected in the in various countries, because we have students from the various countries. So basically these are the things, these are the main points. For that we need international copyright law. Now there is next that what is, I mean, as I told that what is the international copyright law? It is basically the collection of treaties and collection of agreement. Now we will see that what are the important treaty for the protection of international copyright. So there are international treaties which provide automatically for all creative work, as they are fixed in any medium. So here medium means any book, any CD, any recordings, anything should be. So that is the medium. So if any work is fixed in the medium, then that is automatically protected for the global, and but that is basically protected in that only state members of that in particular international treaty. So for copyright protection, there are basically two important international copyright treaties. There are many, but these two are which are used frequently. So one is Bond Convention and another is Universal Copyright Convention. So first we will see about that what is the Bond Convention. Bond Convention, it is basically the protection for artistic and literary work. That means it is basically for the protection of protection of copyrighted work. It was signed on 9 September 1886 in Bonn, Switzerland. That's why, because it was signed in Bonn, that's why it's called Bonn Convention. There are 38 articles in Bonn Convention which are provided to protect copyright internationally. And as of date of October 2022, there are 181 state members of Bonn Convention. If there is some changes now, you can just go and Google that how many state members of Bonn Convention. But as per my knowledge, till October 2022, it is 181 state members. It is basically administered by WIPO, World Intellectual Property Organization, as I told in my very previous slides that very previous sessions, you can say that World Intellectual Property Organization is basically a organization which have administration power to uh, yeah, you can say to govern all the international IP works. So here also Bond Convention is administered by YP because Bond Convention is for the protection of copyright, that is basically the intellectual property. Now, it is the most significant international treaty for international copyright protection. That means most of the countries are the members of this country and it is used frequently. Now, what are the subject matters which covers under the copyright? Which covers under the Berne Convention, as we discussed in our previous slide, that as per our Indian Copyright Act, there are some subject matter which covers for the copyright protection. So, like this here also, there are some subject matters which covers for the copyright protection under Berne Convention. So basically, as there are 38 articles, so Article 2 among that 38 articles basically describes works protected under Berne Convention. So these are basically literary works, scientific works, and artistic domain. So these are the works which are basically covered for the protection under Berne Convention. Now, what are the rights provided under Berne Convention to copyright owner? As in Indian Copyright Act, it's given rights provided to copyright owner. Like this here also, there are rights provided under Berne Convention to the copyright owner. So first is right of translation. We have discussed it earlier also, but in this session, I will also discuss this, that what is the right of translation? It is basically the right to translate your work in any other form or in any other language. Like, see, if you have written some work in some book, work for the book, so you have written some book in the English and now you want to translate it in Hindi, so you have right to translate it in Hindi. No one else can you or without your permission can translate your work in other language. So this, in short, you can say what's written here. In short, it is basically this is right of translation, and this is for given to the copyright owner for the for their original works, not for the any copy works or any something other works. Now, second is right of reproduction. So what is the right of reproduction? This has been also discussed in previous session, but as it is the completely new session, so we will see that what is the right of reproduction. So it is basically right of reproduction of your copyrighted works. Like, what do you mean by reproduction? Reproduction means that you are making copy of other. Like, you have some sound recordings in one CD and now you want to make copies of that CD. So this is the basically right of reproduction. any sound or visual recording shall be considered as a reproduction. Like you have done some sound recordings and anyone else is making the copies of that sound recordings in any form, in any medium, then it will come under the reproduction. And for this, obviously, that person needs to permission from the original copyright owner. Now, what another one is right of performance. So this is the basically right to the copyright owner to do performance on their original work. So they can perform their work anywhere in any form which they want. Like if someone has some song, some song, so he can perform this song anywhere he wants. And if anyone else wants to perform their songs for the economical reason, for the economical gain, then obviously they must need permission from the original copyright owner. Now, right of broadcast, it is basically for the broadcasting of your work. Like it can be done through the wireless or through the wire. In nowadays, it is done through the only basically mainly through the wire, that through the internet or some other mediums. And it includes also rebroadcast of your broadcasted work. Like you have some broadcasted some movie and you want to rebroadcast it, or some if someone else wants to rebroadcast your movie, then obviously he will take permission from you, who is the original copyright owner, who have originally broadcasted that movie. So this is the basically right of broadcast. Now, right of public recitation, it is basically through the authorizing the public recitation of author's works, and it includes basically recitation by any means or any process. It's not like that it is fixed to the one mean or one process. So if you want to recite any copyrighted work in any form, then obviously you will have to take permission from the original copyright owner. The next is right of adaptation. So it is basically authors can enjoy exclusive right, or you can say they have exclusive right of authorizing adaptation, arrangements, alteration of their works. Like no one else can make some alteration in their work, because it can go to the reputation of that the copyright owner, of the original owner, of the creator. So this right is given to only the copyright owner. And if anyone else does this, he needs permission from the original copyright owner. And if he doesn't take permission, then obviously he is violating the copyright rules. Now there are some rights for the sound recordings. So if as I discussed earlier also, like if you have some song in some, you have done some voice recordings, then for that you have the only right. So and this is done basically in the form of musical work. And if any other wants you to use your sound recordings in any form, then he should must take permission from you. Now there are cinematic graphic rights. This is for the basically for the whole movie, you can say. So if anyone wants to reproduce your work, or wants to adapt your work, or wants to distribute your movie, then he needs permission from you. And then there is inalienable rights in original works. So it is basically like if any author dies because of some reason, and he has still some rights over their work and other things, then it will be original manuscripts of writers, composers enjoy right to interest in any sale of the works. So then subsequent to the first transfer by the author of the book, or if the author is not there, then it will be given to the legal representative of the original author. Now we will see that what are the terms of protection, that what are the basically duration time of the protection under Berne Convention to the copyright owner. So in general, if we talk, like it is the protection of the lifetime of author and 50 years after his death. If you remember, in Indian copyright, this year is 60 years. So for under Berne Convention, it can be 50 years. So minimum it should be 50 years. No one can keep it below to the 50 years who are the members of Berne Convention. For cinematography works, so the term of protection shall expire 50 years after the work has been made to the public. Like if work has made to the public today, then it will expire after 50 years from today for the cinematographic works. It is not like for the after the death of the author or of the creator, something like this. In case of anonymous or pseudonymous works, the term of protection granted by this convention shall expire 50 years after the work has been lawfully made available to the public. Like if there is some work and no one knows that who is the author, like this type of things, then there will be copyright, but it will expire after the 50-year work, 50 year when it came to the public lawfully, like it is published on any platform, so it will be 50 years. However, if in mean, if author's identity is disclosed, then this protection will goes to the paragraph 1. And what paragraph 1 says? Paragraph 1 says that term of the protection is the lifetime of the author and 50 year. So now this 50 year will change to the whole lifespan of author and plus following 50 years. So these are the basically terms of protection. And now if we talk about the photographic work, then it is 20 years from the making of such photographic work. Now if we, as I told already, that if we talk about the terms of protection, then countries of the union may grant of term of protection access to those provided by the Berne Convention, but not less. Like Berne Convention has provided 50 years, I mean lifetime of authors plus 50 years. But in India, it is lifetime of author plus 60 years. So, but India has not decreased the time; he has increased the time. So, if anyone wants, they can increase time, but they can't decrease time, which is mentioned already in the Berne Convention. Now, in any case, the terms shall be governed by the legislation of country where protection is claimed. However, unless the legislation of country otherwise provides that not exceed the term fixed in the country of the origin of the a work. So, this means that like it is protected to the different countries. Okay. So, if what is the country of origin has given the term of protection, others country can't exceed that protection time. Now here is one important question, that what is the country of origin. So we will see this in our next slide, that what is the country of origin. Basically there are three different points which define that what can be country of origin. So if we talk about the first in general, then work first published in the country of union will be the country of origin. Like if any work it is first published in India and then after that it published in the different countries, in the different union countries, then India will be the country of origin. Second, if works are published simultaneously in different countries of the union, like it is published here also, there also, there also, in different countries also, the country of, then what will be the country of origin? It's not like that it is published first here, it is published on the same day to the different countries. Then here the country of origin will be the country providing shortest duration of the protection. Like what is the, whichever country is giving the shortest duration of protection, that will be the country of origin for that particular one. Now, third situation can come like that some works published simultaneously in countries of the Union and in some other countries also which are not the part of Union. Like if India is the member of Berne Convention, then it is published in India. And if Pakistan is not the member of the Berne Convention and it is published, that work is published in the Pakistan also, then what will be the country of origin? So in this case, country of origin will be the country of the union, of course, because we are talking about here about the Berne Convention. So if we need to take consider any country of origin, then obviously we will see that in which country who, and if that country is the union country of that Bond Convention or not, then that country will be the basically country of the origin. So now I think it is clear that what is the country of origin, and then accordingly we can decide that what rights or what should be the terms of right given to the copyright owner. Now, there are some moral rights also provided by the Bond Convention. So, what is the basically moral right? So, if first is that right of author to claim authorship of the work and to object to any distortion, mutilation, or other modification or other derogatory action in relation to the said work, which would be the prejudicial to author's honor or reputation. As I told earlier only, that right have that author has right to claim authorship of work, and it is the moral right that any author can object if there are given some modification, there are given some changes, some other action related to their work, which is which is harmful for the author's honor or reputation. In that case, author has right to object that work. Obviously it is modification, it can be done, but if it is giving some prejudicial to author's honor, then obviously author has moral right to object that work. Now what is the second right? This is the rights granted to the author even after their death. It should be maintained at least until the expiry of the economic rights and shall be exercisable by the persons or institution authorized by the legislation of the country where protection is claimed. So it means that if any author dies and that right is for the author's lifespan plus 50 years, then in that case different countries can't stop their right or can't ban their right. That right will be still valid, and it will be exercisable by the persons who are the legal representative by the of that deceased person. So these two rights are basically moral rights. So first right is that to object any work which is which is getting harmful for the reputation of author, and second, there should be valid right for the author's economical right even after the death of the author, and after the death of the author it will be exercisable by the legal you can say legal representative of that particular person or that particular author. Now we will see about the second convention, that is the Universal Copyright Convention. As I told, Bond Convention is the most important convention. So Universal Copyright Convention, you can say it is basically the alternative of Bond Convention. So when Bond Convention came in existence, so some countries were not agreed and they didn't become the part of the Bond Convention. At that time, Universal Copyright Convention came. So it was basically done in 1952 in Geneva, Switzerland. So it is also for the protection of copyright globally, and as I told, it is the alternative of Bond Convention. So what are the main features of Universal Copyright Convention? So basically, main feature of Universal Copyright Convention is that no signatory nation should accord its domestic authors more favorable copyright treatment than the authors of the signatory nations. Uh, there are some 10 countries in, just for the example, there are some 10 to 15 countries in this UCC. And so like if India is also the member, so India cannot give more favorable treatment, or you can say more special treatment to their nationals for the particular for any copyrighted work than others nationals. So it's their copyright treatment or their copyright protection, their copyright rules, all will be same. What will be for the Indian citizen, it will be same for the other citizen also. So this is the main feature of UCC. And then minimum term of copyright in member nations must be lifespan of author plus 25 years. Like in Bond Convention, it is lifespan of authors plus 20 plus 50 years. So here it is lifespan of authors plus 20 5 years, except photographic works and works of applied art, for which it is given 10-year term from the publication of that particular work. Now we will see that what are the basically principle of international copyright. As I told that your UCC it was the just alternative, so there are no so many things to describe, as I have already described all the Berne Convention, which is the most important treaty for the in now for the international copyright protection. So now we are see that if there is any other international copyright treaty also, then what are the basic principle on which they work. So first is national treatment, as this is the main feature of UCC also, that member countries must provide the same level of protection to work of other nationals as it does to work to its own citizens. As I described already, that no nation can give a special treatment for the copyright protection for their to their citizen than other citizens. So there should be equal treatment, there should be equal level of protection to all for who are the members of that particular international copyright treaty. Now it should be a state versus a state only. Like here it should be keep in mind that protection is given to the citizen of that particular country. It is not like given to the particular individual. So it is a state versus a state. So a state whoever is the state member of that particular country, citizens of their country will are liable to avail all benefits which are provided under that international copyright treaty. Now third is that minimum standards are fixed for each member country. As I told that as we see in if anyone is the uh, member of the Berne Convention, any one country, then in general for the literature works, like there is given protection time author span plus 50 following years. So no member country can decrease this time period. Like no member country can keep this time period protection 40 years, 45 years, 48 years. I mean, author of lifespan plus 48 years. So it must be minimum, it must be author lifespan plus 50 years. Of course, if anyone wants give more protection duration, they can give. Like India has given 60 years after the author's lifespan. So it's okay, but it should not be less than 50 years. So now it's time to know that your curiosity, that how much you are curious to know. If you remember, in last session, I have left some unanswered question like how we can protect our copyright work globally, then why we need to protect our copyright globally, and then what is the international law of copyright. So as I think that I have given answers of all these questions which were unanswered in the last session. So I have given that what is the international law for copyright. So basically it is the collection of treaties, and then we saw that why we need to protect copyright work globally. So if we want to give answer of this question in one statement, then we can say that because nowadays is digital era, that's why we need to protect copyrighted work globally. And how we can protect our copyright work globally. So obviously for that there are different treaties, and we have discussed for the Berne Convention and UCC. So here you can see Berne Convention is the most important international treaty for the protection of copyright. Now so we talked about the copyright search, about the copyright subject matters, rights provided by the copyright, how can we register, how can we protect our copyrighted work globally. So now it's time to know that if anyone is infringing our copyright, then what should we do or what can we do? Like if anyone is making reproduction of your work, or if anyone is translating your works in other language or in other works, so is there any provision in Indian Copyright Act? Yes, of course, there are some provisions. So if you are curious to know that what is the copyright infringement and what are the provisions for copyright infringement or copyright infringers. So then let's tune with us, and in my next session, which is coming very soon, we will discuss about these topics. So, of course, if you are curious about to know that how can you protect your work, or not you can say protect, or you can say that how can you protect your work from other infringers. Then just keep tuned with us, stay in touch, and obviously follow back to ITLS Academy. You can find it on Instagram, Facebook, Twitter, LinkedIn, WhatsApp, everywhere. So you don't need to search any specific particular social platform, as now it is digital era, you can find it everywhere. So subscribe it, and thank you so much for watching, and obviously keep tuned and stay in touch for the following sessions. Thank you so much.